choosing an executor is one of the most important decisions in your will, and one of the least understood. Most people simply pick their spouse or their oldest child and let it roll from there, without thinking about what the job actually involves. Today I'm going to walk you through what an executor does, what to look for in the person you choose, and some of the traps I see families commonly fall into. I'm Chad Graham. I am an estate and probate lawyer in Edmonton, Alberta. This video provides general information for educational purposes only. It does not create a solicitor-client relationship and is not specific legal advice tailored to you. For any concerns or questions you have, please speak with your own lawyer. Let's get right to it. What does an executor actually do? Being named as an executor is an honor, but it's also a job, a real job, and most people don't understand what it involves until they're in the middle of it. For example, your executor will need to locate your original will and secure your assets immediately after death. This means locking down the house, identifying bank accounts, finding investment statements, tracking down life insurance policies, making sure bills aren't behind. They then need to arrange your funeral and burial costs unless you've already taken care of those arrangements yourselves. After that, they need to apply to the Court of King's Bench for a grant of probate in most cases. That's a court order that confirms the will is valid and gives the executor confidence and authority moving forward. Then they need to notify all the beneficiaries who are in the will and any person who would have inherited in intestacy, those with a potential claim. Then they have to publish creditors' notice so anyone owed money by the estate can come forward. They have to then pay all the debts, the funeral expenses, and the taxes out of the estate before anything else is distributed. Then they have to file the deceased terminal T1 tax return and potentially a T3 trust return for the estate. This usually requires working with an accountant. Managing estate assets during the administration period is also essential. That might mean maintaining property, managing a rental, or running a business temporarily. Distributing the estate to beneficiaries is done last only after all the debts are cleared, the creditor's notice period has expired, and a tax clearance certificate has been received from the CRA. This process takes, at minimum, months. For complex estates, it can take more than a year. Your executor is on the hook that entire time, and they can be held personally liable for mistakes they make. That's the job. Now let's talk about who should do it. Qualities that matter. You're not looking for the person you love the most. You're looking for the person best equipped to handle the job. Those are different questions. Here's some of the qualities that matter. They need to be organized and detail-oriented. Estate admin involves paperwork, deadlines, and financial tracking. Someone who loses their own mail is not the best candidate. They have to be financially responsible. Your executor will be managing real money, potentially a lot of it. You want someone who handles their own finances well. They have to be trustworthy and honest. Your executor will have access to everything. They have to be available. As I said, this job takes time. Someone who travels constantly or lives overseas or is already overwhelmed in their own lives with the quadruplets they just had might not be the best choice. They need to be emotionally steady. Remember, your executor is going to do their work and make decisions while everyone, including themselves, are grieving. The ability to stay calm under pressure matters. And of course, they have to be willing. This is one I've found a lot of people actually forget. They don't talk to their potential executors. Being named an executor in somebody's will and finding out after they died is not a gift. It's a burden. And if they didn't agree to it, it can be troublesome. Now, most people pick their spouse as executor. And in most cases, that's probably the right one. They know your finances, they know your wishes, they have the most direct interest in making sure things are handled properly. But there are situations where your spouse might not be the best choice, especially if they're significantly older than you or have health concerns. They might not be the best position to serve when the time comes. If you're in a blended family, Naming your spouse as an executor can create some awkward situations and even potentially conflicts of interest. Remember, they're both the executor managing the estate and probably a beneficiary with their own financial interest in the outcome. And children from a prior relationship may not feel comfortable with that tension. Of course, if your spouse is not comfortable with financial management, legal paperwork, or dealing with institutions like banks, the CRA, the job might overwhelm them at the worst possible time. Now, none of this means your spouse isn't the right choice. It just means it's worth thinking through before you default to them. Another common choice are adult, children, and family members. Here's a few things to think about there. Naming one child over the other can create tension, even if it's the right decisions. Naming all of your children as co-executors, on the other hand, feels fair, but it can be real impractical. I'll get to that in a minute. Siblings, parents, and other relatives can all work well, but think about whether they'll be willing and able to serve in 10 or 20 years. And then remember that estates take a long time. Consider the family dynamics honestly. If two of your children don't speak to each other, naming them co-executors, well, that's an issue. Naming one of them as executor is also an issue. So you might have to manage some of these as you go through. Maybe a neutral third party is a better call. So let's think about non-family members as executors. You're not limited to family. You can name a trusted friend. I've seen this work well many times. There are professionals, some lawyers and some accountants, although many don't want to, but they may agree to handle your estate. They'll certainly charge for their time, but they'll do the job competently and without emotional attachments. A really good option for larger and more complex estates is a trust company. Trust companies are professional fiduciaries. This is all they do. The trade-off is cost and a much less personal approach. But don't rule out these non-family options if the circumstances are right for you. Now, I wanted to make a brief mention about co-executors. I usually don't recommend this. It feels like this fair solution, and it certainly sometimes works, but here are a few of the risks. Co-executors generally must act unanimously unless the will says otherwise. This means every decision, selling a property, the price at which it will sell, distributing an asset, who gets the car, choosing a real estate agent, requires exact agreement from all of them. And if they disagree, the estate stalls. If co-executors are in a conflict they can't resolve, the only resolution may be to go to court and have an application to remove one of them. That's expensive and emotionally devastating. Practically, it's also a huge pain. Coordinating signatures and decisions around multiple people. Every bank visit needs both of them. To cancel the cell phone plan needs both of them. Especially if they live in different cities, this can slow everything down. So if you do name co-executors, your will should specify whether they must act unanimously or by majority, and consider whether the people you're naming can actually work together in a stressful time. Another thing to consider is that you always want to appoint an alternative. It's simple, but it's critical. The person you wanted to do it may not be able to. They could predecease you, or they just might not be in a position to at the time. If your only named executor can't or won't act, and there's no alternative, then your family has to go through the court process of a grant of administration, even though you have a will. It's more expensive and more time-consuming. Executors get compensated. Most people don't know this. In Alberta, they're entitled to what the law calls fair and reasonable compensation for their time and effort. Remember the list I gave you earlier. For many estates, this looks like something like 5% of the estate. But that's a guideline, not a rule. Your will can address compensation directly, and you can choose an amount, a percentage, or simply state your executor is entitled to a reasonable amount to be determined with their lawyer, the family, and the courts later. Here's the practical point, though. Do not expect or anticipate your executor to do this for free, unless it's your spouse. The job takes real time, sometimes hundreds of hours, over a year or more. And acknowledging that in your will, or at least in a conversation, goes a long way. Now, what about if you've been named an executor and you're not really sure about all this? I've seen that happen. That's even happened to members of my family. It's okay. You're not legally obligated. to act as the executor just because someone named you in their will. Before the person dies, it's worth having an honest conversation. Tell them you're very honored, but you're not sure if you can fit it in. They can name someone else, and even name you as an alternate if you're willing to be a backup. After the person has died, you can still renounce. That's a formal declination to act filed with the court. You do this before you've intermeddled in the estate. That means if you've started taking steps as an executor, assessing accounts, dealing with assets, then it becomes much more complicated to step back. So if you've already started, you've intermeddled, and you're in over your head, you can apply to a court to be removed, but make that decision as early as possible. The bottom line, being named an executor is a major responsibility. If you're not confident you can do it well, it's better for everyone, including the beneficiaries, if you just say so. We walk through executor selection with every client as part of our estate planning process. It's one of the most important conversations you can have. If you're not sure who to name, or if you've been named and you're not sure where to start, I put a link below where you can get started with a consultation. Thank you for watching.